Live from deep in an underground bunker in East Tennessee, this is America's premier mortgage field services expert, Paul Williams.
Good afternoon, ladies and gentlemen. I'd like to welcome you back to another edition of Foreclosurepedia Podcast. Foreclosurepedia Podcast presentation of the Foreclosurepedia Radio Network, which premieres each weekend. We're coming to you with a special edition of the Foreclosurepedia Podcast today. It is the 30th of August, 2018. The time is 1300 hours Eastern Daylight Time. We're speaking to you today from our new Northeast Command Center. That's right, our new Northeast Command Center right here in Mount Desert Island, Maine. I'm going to tell you, ladies and gentlemen, the view is spectacular. It's breathtaking. And by the same token, I guess that's really the way things should be when we get down and begin to talk about the meat of our podcast today. Serious discussion today, ladies and gentlemen, because what we're dealing with today is the misclassification of employees. I want that to sink in for a moment because for the past 2 decades, the mortgage field services industry has created this shell, this artifice, wherein management has pretended that labor exists in a subcontracting point of view. And you know, since 2012, the mortgage field services industry has known that this is a fallacy. In fact, it is known about the liability associated with its common practices of misclassifying employees as independent contractors. To that point, Blue Check Enterprises, in the first case, 2010, federal, paid a gentleman by the name of Brad Hurst 6 figures to bring an end to the challenge that Hurst was, in fact, a misclassified employee. Now, Brian Drain, at the time, was the chief technical officer of Blue Check Enterprises and ACA. Brian Drain is the individual whom informed us of that settlement, and it's actually documented, albeit not the amount, federal court documents. And over the past 8 years, tens of millions of dollars have been expended upon a failed policy of saddling labor with the liability by and through spurious language contained within master services agreements, parading around that subcontractors were not, in fact, employees. To date, the National Association of Mortgage Field Services regime has been the only trade association within the industry space. And in each case brought forth claiming misclassification of employees, it has been against a NAMPS member. Additionally, each case which has been brought forward at the federal level has prevailed. In addition to the costly toll of litigation, which could be preempted, state regulatory agencies are now entering the arena, carving out a king's ransom, relying upon both state and federal rulings, which are now the law of the land. We're going to get into that in a moment, and we'll be right back after a word from our sponsors. As we were speaking before the break, we were talking about the misclassification of employees within the mortgage field services industry. You know, recent rulings emanating from the California State Supreme Court, as well as U.S. District Courts in California, have impacted the mortgage field services industry, specifically the Dynamex decision. Now, Dynamex came on the heels of a multitude of litigation that was flooding the state of California. And it was all surrounded what is known commonly as the ABC rule. 50 some years ago, employment law was created, and it basically stated this is what an employee is, and this is what an independent contractor is. And over the years, we've had lobbyists and legislatures and such attempt to continue to push that bar back. But the law has never changed. And in fact, after studying information from the California Employment Development Department, also CalPERS, we started to find that the California State Supreme Court finally had to dig its heels in and determine precisely whom is and whom is not an employee. And in Dynamex, California State Supreme Court shifted the entire landscape. The pendulum shifted in such a diametric manner that over 2 million independent contractors were classified as employees. This just happened a month and a half ago. The recent Dynamex ruling from the California State Supreme Court and the landmark decisions in both the Vincent settlement. Now, this was Bennett Vincent who sued the former asset management specialist, AMS, which was later bought out by Mortgage Contracting Services, MCS. MCS paid millions to make the Vincent matter go away. And in Bowerman, Fred Bowerman and his wife sued Assurant. Now, Assurant had bought out Field Asset Services. What happened in the Bowerman case was that in 7 out of 100 and some cases, the federal juries came back with verdicts totaling $2.2 million, just in 7 of those cases. As a direct result of that litigation, which is still ongoing, NationStar bought out Assurant. So those companies are gone. Gone. In addition to the millions of dollars in federal jury verdicts that were handed down, MCS attempted to simply amend their master services agreement, demanding that labor could never again file class action litigation. That was their solution. Their solution was not to obey the law. No, this NAMPS regime member elected to corral labor in such a manner that it violated their civil rights. All told, the first round of financial ramifications, with respect to employee misclassification, are currently estimated to be nearing $25 million. When we talk about California, that number is expected to climb probably to well over $50 million. Now, we're not even talking about, so we have 2 pools here. So we have lawsuits that are being filed. For example, we have the ServiceLink lawsuit just filed. That's the former LPS outfit. And when LPS sold off its title plants and then divested itself, and Fidelity broke it up and created Black Knight and created the ServiceLink as the new LPS, they just got sued down in San Diego County at the state level by inspectors. They're going to lose. It's a fact. They're going to lose because the California State Supreme Court decision in Dynamex controls. Nationally, when we look at precisely what's going on, remember, California has a more stringent application of the ABC rule. Nationally, we have about 23 states that subscribe to the ABC rule. And we're going to get down to that in just a moment. With that said, whether or not California's application of its targeting of the industry prime vendors will be successful, I mean, this is a foregone conclusion. The EDD has already begun a specific and targeted auditing process, specifically targeting NAMPS regime members. And because of California's recently accelerated auditing process by the EDD and CalPERS, because of the fact that the law draws its genesis from the original ABC test out of Massachusetts, I feel it's safe to say that virtually all blue states will adopt the rulings that California is pushing forward. But I digress. Let's actually talk about what is the ABC test. There's 3 prongs to this. First prong is, and I'm going to quote here, that the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work, and in fact, that the worker performs work that is outside the usual course of the hiring entity's business, and the final prong, that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. That's everybody. And while we're talking about the industry today, these ramifications, these are going to be across the board. Look, the court was very specific when it described the Dynamex business model. One could almost remove the name Dynamex and insert any mortgage field services industry company name and have an identical interpretation. You know, here's how the California Supreme Court put it, and I quote, "In the present case, Dynamex's entire business is that of a delivery service. Unlike other types of business in which the delivery of a product may or may not be viewed within the usual course of the hiring company's business, here the hiring entity is a delivery company, and the question whether the work performed by the delivery drivers within the certified class is outside the usual course of its business is clearly amenable to determination on a class basis." That's serious. The court's saying, look, it is easy to identify a class. As a general matter, Dynamex obtains the customers for its deliveries, sets the rates that the customers will be charged, notifies the drivers where to pick up and deliver the packages, tracks the packages, and requires the drivers to utilize its tracking and record-keeping system. As such, there is a sufficient commonality of interest regarding whether the work performed by the certified class of drivers who pick up and deliver packages and documents from and to Dynamex customers on an ongoing basis is outside the usual course of Dynamex's business to permit that question to be resolved on a class basis. Because each part of the ABC test may be independently determinative, the employee or the independent contractor question, our conclusion that there is sufficient commonality of interest under Part B of the ABC test is sufficient to support the trial court's class certification order. You know, in adding fuel to the fire, a Fair Labor Standards Act suit was filed on the 18th of May, 2018 in the United States District Court for the Southern District of Georgia. Now, in all these MSAs, no one's allowed to sue, no class action, arbitration everywhere, and I've never heard of one arbitration case. Maybe a couple out there. I've never heard of them. The FLSA is exempted, as are any claims brought in accordance with any organization formed, created by, through, and under the National Labor Relations Board. In addressing that Georgia case, plaintiff's attorney Michelle R. Fisher of Nicholas Castor PLLP explained, quote, "Companies cannot avoid overtime and minimum wage requirements simply by requiring their workers to label themselves as, quote, independent contractors, end quote. When companies control their workers like employees, rather than giving them the independence of individuals in business for themselves, they must comply with wage and hour laws, end quote. The suit claims unpaid overtime, minimum wages due to inspectors whom were performing inspections upon default assets within the industry. Not only is the FLSA collective action unique, the fact that it separately addresses inspectors as a class is most assuredly novel. Now remember, that happened in May. Just a week ago, we had a filing against ServiceLink in the state of California. To that point, we have sources speaking on condition of anonymity that suits are gearing up for the state of Massachusetts, New Jersey, and Ohio. Identical suits. Not only is the FLSA collective action unique, what we need to really understand here is it's not just about inspectors. Inspectors, when we talk about damages and fines levied, for not paying the proper wage, and let me digress there just for a minute, because remember, these are all federal properties. And federal properties are bound under the covenant of the SCA, the Service Contract Act, which demands the payment of prevailing wage in accordance with the Department of Labor statistics specific to geographic area. Look, the challenge to addressing employee misclassification is that no one in the industry, other than labor, has a vested interest in doing such. This is a $1 trillion a year industry, and there is zero regulation. In fact, there has been a calculated and identical response to this type of litigation in the past by NAMP's regime members, and that response has been to circle the wagons and add legalese to the Master Services Agreement. There are 3 tests that are commonly used by government agencies in determining a worker's status. One is the common law test. One is the economic reality test. And we have the ABC test. The most important test is the common law test. It is a 20-factor test used primarily by the IRS to establish whether an individual is an employee for federal employment tax purposes. Businesses should pay particular attention to this test because the IRS is the federal agency most likely to investigate a classification problem. A failure to correctly classify a worker under the IRS test often draws the attention of other government agencies that may begin their own investigations and impose their own penalties for any misclassification. So I want that to sink in because I'm going to use a term here. Shit rolls uphill and downhill. Shit rolls both ways. Make no mistake about that whatsoever. When we're actually beginning to look at this, we have to understand what is the true genesis? What really kicked this off? Well, I'll tell you who kicked this off. It's President Donald Trump. And let me talk to you about that for just a minute. Bloomberg had this to say about President Trump's 2018 tax bill overhaul. Quote, "It's an unhappy time to be a high-income professional in a blue state or their governor. The new tax law, which caps the deduction for state and local taxes at $10,000, amounts to a roughly 1/3 increase in their effective state and local tax rate. That will be an ugly hit to the pocketbook. They will fiercely resist any attempt to raise taxes further. Bad news for mayors and governors who are often facing big pension holes that are eventually going to need to be filled with taxpayer money. Worse still, they will probably put pressure on said politicians to lower taxes. And some of them may start shopping for residences in lower tax locales, taking their valuable taxable income with them if they go. Last fiscal year, we had an exodus of over 236,000 people from the state of California. It's a fact. State regulatory agencies, they're scrambling to make up for the tremendous loss in revenue as a direct result of the largest exodus from blue states by individuals and businesses since, perhaps the Civil War. That loss is from a combination of the blue exodus as well as the new Trump tax overhaul. Since Governor Jerry Brown has been sworn in, becoming the oldest governor in state history, 243,099 people have fled California on net for other states, taking $7.794 billion with them to states that don't have such high taxes and onerous regulations that make housing unaffordable for middle-class households. The top recipients of Golden State refugees last year were Texas and Nevada, two states that have zero income tax. California, meanwhile, levies the highest top marginal income tax rate in the nation. Policy, like elections, has consequences. Revenue alone is not the sole determining factor, though, when searching for the why with respect to the recent onslaught of California regulatory audits. For years, California has been incensed by the lack of responsibility shouldered by financial institutions when it came to the 2008 housing crisis, which swept across the globe. If Wall Street was the eye of the financial hurricane of the last decade, then California was the equivalent of the tropical oceans that provide the heat to feed such raging storms. More than any other place, California was the source of mass mortgage lending, ballooning home values, and dubious subprime operations. And behind that was California's leading role in U.S. urban, industrial, and fiscal developments that underlay the stresses and strains on the financial system. California needs to be recognized as a pivotal site of the bubble of the 2000s, the bursting of the financial markets, and the Great Recession that followed. Taking a parallel from the 2008 housing crisis, the entire house of cards which the industry is built upon rests firmly on the foundation that all of its physical labor performed upon client assets occurs with independent contractors. That's key. It's key, and it's a fallacy. This precarious foundation, this concept that the master services agreement makes the independent contractor, has eroded to the point of permanent instability. Moreover, though, this false belief leaves ripe the justiciability against the soft and unprotected underbelly of the financial institutions and government-sponsored enterprises. It does not take a rocket scientist to realize that a state regulator wielding the power of numerous judicial rulings and the mantle of the state may easily extract allocutions in exchange for reduction in fines. And make no mistake whatsoever, vicarious liability applies. And it's not just this industry. The National Association of Realtors is probably the best example of a similarly situated industry wherein employee misclassification has become the elephant in the room. And contrary to misguided public consensus, realtors are not necessarily independent contractors. It's a great case, happened in 2012. Barasani versus Caldwell Banker Residential Brokerage Company. 15 November 2012, plaintiff Ali Barasani filed a putative class action complaint in Los Angeles Superior Court against Caldwell Banker, alleging that Caldwell Banker had misclassified current and former affiliated sales associates as independent contractors when they were, in fact, employees. This is in 2012, ladies and gentlemen. Long before Dynamex, long before Shannon Liz Reardon had got the $100 million settlements out for Uber, the $27 million settlements in Lyft. Caldwell Banker, for whatever reason, chose to pay $4.5 million to settle the case. The independent contractor relationship between brokers and their salespeople is a long-standing tradition in the real estate industry. And yet Caldwell Banker chose to pay $4.5 million to make the case go away. The problem we are seeing time and again is that the industry, including all of its intricately interwoven provider satellites, is refusing to bring the matter to a conclusion. There's no two ways about this. No ways around it. And if you think that it was simply Coldwell Banker that did the settlement, there's a case. There's a case, Monell versus Boston Pads. This is an interesting one because of the fact that it was filed, excuse me, up in Massachusetts. Now, the head of all heads and unions is called the AFL-CIO. And when the AFL-CIO saw the opening in the Monell case, they realized a couple of things. First, you had a governor up there, Deval Patrick, I believe, if memory serves right. And he set up a task force, and that task force dealt with employee misclassification. And in essence, what the task force said was that misclassification exploits vulnerable workers, deprives them of their legal benefits, gives unlawful businesses an unfair competitive advantage, illegally drove down violators' taxes, wages, harms the consumers, defrauds the government, etc. ad nauseum. Now, the AFL-CIO realized that here was an opening. Here was a soft underbelly. The NAR, with all its money and all of its pride, thought it really was something. And I tell you what, they got a kick straight in the guts. You know? Because what happened was in Monell, the court was quite clear that determination of whether realtors are misclassified employees was a fight for another day. They didn't say that those realtors were independent contractors. What they stated is that the state legislature needed to address the fact. So what we have here now is you have objective information, which is based upon fact, and then you have subjective. There is a subjective opinion and a belief that realtors, by law, are independent contractors. And in fact, we realized in Monell that they're not. Now, I'll make the wager that AFL-CIO probably ponied up $250,000 or so for its amicus brief, its friend of the court brief that it issued in Monell. And while they lost the case, they actually won because the court did not rule that those realtors were actually independent contractors. And look, this has a lot of bearing when we talk about our industry. A question which presents is not whether the business model currently exhibited, by the industry guarantees employee status, but to what extent it does such. I mean, I've belabored discussions in the past with respect to the status of the realtor to demonstrate that perceptions are dangerous. Even the NAR agrees with the tenuous position that they find themselves in vis-a-vis uncharted waters in an unfunded regulatory landscape. I mean, this is important. Remember, for the AFL-CIO to file an amicus brief means that they are hunting for bear. And to that point, they're going after realtors. And you may go ahead and guarantee that our industry spats are high up on the radar. We talk about the costs of FLSA, Fair Labor Standards Act litigation, and the carte blanche attached to its rulings. FLSA settlements costed employers $403,950,000 in fiscal year 2016 alone, according to Miranda Mondry, a writer for T-Sheets by QuickBooks. So just in that year alone. Now I want to talk about some of those settlements in 2016. All right? The sacrosanct belief that realtors and bankers always have and will continue to be exempted from the rule of law is proving to be yet another precarious house of cards upon which this industry lies. Norms with which both legislatures and the judiciary have followed for decades are now being overturned. For example, Bank of America and Merrill Lynch ponied up $14 million to settle 2 FLSA claims in 2016. In January 2018, the beleaguered Wells Fargo entered into yet another $13 million settlement in California to address claims from customer sales and services representatives. April of 2017, Summers Schwartz secured a $6.55 million settlement on behalf of approximately 28,000 current and former exotic dancers working at 64 nightclubs across the country operated by Deja Vu Consulting Incorporated. The strippers are getting game here. Strippers. I want that to sink in. The wage and hour class action lawsuit claimed that the dancers were intentionally misclassified as independent contractors rather than employees, so that Deja Vu could avoid paying them minimum wage. It's a violation of the Fair Labor Standards Act, as well as many state labor laws. Ladies and gentlemen, there is no I in we, and there is no me in team, period. And while many are talking about the other day's U.S. Supreme Court ruling in the Epic Systems Corporation case, tragically, it really has no bearing upon most of the litigation impacting our industry. The core issues facing clients, vendors, and labor is the misclassification of employees itself. As an association, the International Association of Field Service Technicians must realize that its membership is a melange of trades. The IFST represents both labor and management with respect to the field services industry. It represents realtors. This is not simply those performing services in the field or those issuing the work orders. The IFST represents individuals whom are processing those work orders, bidding those work orders as well. They represent the distributors whom provide the materials and the peripheral services required to service the asset. And the IFST, most assuredly, represents realtors, as well as their clients, whom function within the distressed asset landscape. The IFST works directly with a plethora of legislative agendas with only a razor-thin differentiations. Why is that? We have 23 states with an ABC rule. And as California begins to reap in the millions, the tens of millions, and I ultimately state hundreds of millions of dollars in taxable revenue and fines, so too will the other states. And for those of you out there whom are naysayers stating firms like NationStar, who's now swinging the big weight around, they're not going to go after NationStar. I remind you only of Ocwen. Ocwen wouldn't get its shit together and California pulled their license. NationStar is no one compared to Ocwen and Bill Irby. Irby went down simply because Benjamin Losky, former director of the New York Department of Financial Services, got a hard-on for him. California is going to get theirs. To address this regulatory onslaught will require daring, originality, and a war chest. It will require solutions. Now, I want you all to think about that for a moment. Solutions. The California Employment Development Department and CalPERS were specific on something I am not sure anyone really caught on to. They said that unskilled labor will be considered as fair game to quantify as employees. And you know what? I'm all for that. Why? Because we, as an industry, need to be getting involved in training. The NAMPS regime has an educational program. It won't pass muster, and it is targeted towards management, but at least they have one. The IFST has one as well, and it does pass regulatory muster. It's built upon a digitally accredited certification system. That is what regulators are looking for. Regulators want to be able to track certifications like they do in any other industry, except ours. Going forward, what are we doing? How are we going to do it? Well, my recommendation is that the onboarding of all personnel begin with a DUNS number, a Dun & Bradstreet number. It is free. And a SAM account, System for Award Management. It is free. You don't need Aspen Grove. Anybody out there who can argue to me that Aspen Grove is legitimate, best speak with Susan Bunnell, the Senior Vice President, Senior General Counsel for all contracts and technology at Wells Fargo in San Francisco, whom informed me that background checks are not required by Wells Fargo for anybody other than third-party service providers. Fact. What does the SAM account do? For free, it completes the background check. It ensures financial solubility. It ensures that the EIN actually exists, and it ensures that the DUNS number exists. And EIN and TIN are only extensions of your Social Security number. They mean nothing. The state of California stated as much. DUNS is different. It defines you as a company. Non-resident legal alien specific to the point of view of business as opposed to the individual. For an industry which has brought in hundreds of billions of dollars over the past 2 decades alone, you know what? I am appalled by the fact that there is absolutely no lobbying ongoing. Now, the IFST is doing lobbying as I hear now, and maybe that's a good thing. Perhaps many may consider the now deceased Robert Klein's attempt to lobby on behalf of his polycarbonate product. The reality is that this industry needs to pay attention to the IFST and needs to be at the forefront of identifying issues and bringing solutions to them with respect to legislative agendas. Moreover, though, our industry needs to be actively engaging upon the optics. In a hyperventilating, ever vacillating 24/7 news cycle, we need to be the entity to whom is looked upon for statements and answers. That's a fact. Control the narrative, control the landscape. The end result of not addressing employee misclassification will be a veritable onslaught of litigation from every corner of the nation. The litigation will be protracted, costly, and, make no mistake, duplicitous. It will be painful. Moreover, though left unchecked, we will see an eventual unionization of the industry, as the AFL-CIO has already begun nipping at the heels of the NAR. Let that sink in for just a moment. If the AFL-CIO took on the NAR, whose budget, lobbying efforts, and statutory backing dwarf the entire combined total revenue within the mortgage field services industry, and that's just for 1 month, they're already looking to make waves here. Change must occur, must be well thought out, and well researched. We must assemble allies and resources from all quarters in order to effectively address these issues. Regardless, there will be certain states where once former independent contractors are now employees. And to that point, the IAFST must stand at the ready to capitalize upon those individuals, whether it be through the National Labor Relations Board or through other mechanisms. The more daunting of the challenge is not so much implementing a legal strategy to come into compliance, but rather the looming necessitation to ensure that all vendors are legally operating within the industry. I'd like to thank you for tuning in for another edition of the Foreclosurepedia podcast. This has been a special edition addressing employee misclassification. Feel free to reach out to me with any comments, questions, concerns. COO@Foreclosurepedia.com. foreclosurepedia.org.